A United States District Court judge rules that machine guns are protected under the Second Amendment. Let's go ahead and talk about it. What's up, Wolverines? Welcome back to the channel. My name is John Crump, and I'm an investigative journalist. I look into 2A related news and other gun issues. Today, we're going to be talking about a court case, but before we get to that, like, comment, and subscribe. It really helps me out. Once again, we are fundraising for the Cub Scouts, and you can find that link down below. Also, if you would like to sponsor a video or two, you can do that, and all the proceeds for those sponsorships will go to the Cub Scouts, and it would help my kids out, and it will help other kids out who cannot afford to do scouting by helping pay their dues. The case we're going to be talking about today is United States of America versus Tamari Morgan. Tamari Morgan was a gun owner that was busted because he was caught with an Anderson and 300 blackout that was converted into a machine gun and a Glock switch. He was found guilty but appealed, stating that his Second Amendment rights were violated because machine guns were covered by the Second Amendment because they were bearable arms. The government tried to argue that machine guns were not covered by the Second Amendment because the Second Amendment only applies to firearms that were around during the founding era, which we all know is false. The judge would use several different cases to come up with his conclusion, and we'll talk about those cases a little bit later, but just so you know, they are Heller, Bruen, Rahimi, and Miller. Those are 4 Supreme Court cases that we will reference throughout this. So, this guy was caught with a Glock switch and a machine gun. He appealed, stating that he is protected by the Second Amendment because machine guns are in circulation, which they are. The state tried to counter by saying that the Second Amendment only applies to arms that were in circulation during the founding era, which we all know is false. I would like to state that the state also used a lot of dicta, and the judge called him out for using a lot of dicta, stating that that could not be used to determine what his decision was going to be. First, let's take Bruen. The Supreme Court Bruen decision does give us an outline to determine if a gun law is constitutional or unconstitutional. The first step in the test is to look at the original text of the Second Amendment. If that original text does not say that you can ban something, then it moves to the second step. And the second step is on the government to show with historical analogs that the law is consistent with the history and tradition of the Second Amendment. Now let's look at the original text. There's nothing in the original text that says that the government can ban machine guns. In fact, the judge pointed that out. After that, it falls on the state to provide historical analogs to show that a law is consistent with the tradition and history of the Second Amendment. Now, Rahimi says that it doesn't have to be an identical twin, but it does have to be similar. And the state failed to produce evidence to that contrary. They try to rely on the dicta that was put out in Heller, but once again, that cannot be used in a court to make a ruling. So the judge was very right on that. The state also tried to rely on the old trope that the machine gun is a military-style weapon and has no place in civilian hands. And this is where Miller comes up. United States versus Miller was a 1939 case that went in front of the Supreme Court, and it dealt with sawed-off shotguns. The Supreme Court ruled that the NFA could regulate shotguns, sawed-off shotguns, because they had no military purposes. You see, during the founding era, people a lot of times had to keep their own firearms for militia service. Since the historical analogs shows that people were not forbidden from having military-style weapons at the founding of the country and the ratification date of the Second Amendment, and in fact, the law actually said the exact opposite, the judge found that the state could not provide any historical analogs to show that the rule barring machine guns was constitutional and, in fact, probably is unconstitutional. Now, does this mean you should go out and buy a machine gun or make a machine gun? Absolutely not, because you would still be violating the NFA. This was decided in the Northern District of Kansas, which is a federal district court, and it was done in a criminal proceeding. This will be appealed. The government can appeal the district court's decision to a higher court, and it is likely the higher court will stay this and maybe even reverse it. We will have to wait and see. But as of right now, it's not a nationwide injunction. It doesn't apply to everyone. It applies to this one particular person, in this case, dealing with the charges that were filed against him and the crimes against him. Like I said, it's going to be appealed, and we'll have to see what happens on appeal. But it is not a message for everyone out there to go make machine guns or to buy machine guns unless you really want to face the wrath of the federal government, which I do not, or you can keep it really, really quiet. But I'm not going to go buy a machine gun right now illegally. Maybe if I do a transfer or something like that, that is 100% legal. But I'm definitely not going to go buy a Glock switch off wish.com because I really do not want to go to prison. So there's your information for today. A little update. I found it very, very interesting, and it will be definitely interesting to see what happens in the future with this case. I'm not holding my breath either way, but I am definitely going to be tracking it. All right, guys, that is it. So stay ever vigilant, stay ever free, keep in the fight. I am out of here. Wolverines, MFers.